Hi there, how are you doing? My name is Tiawa Conrad. I am a lawyer and a private law tutor. And basically today in this video, we are going to be looking at judicial review. We will look at the bodies that are subject to judicial review. We will also define what judicial review is, and then we'll also look at bodies that are not subject to judicial review. So before we start on our class, I encourage you to subscribe to my channel, to like and share, and also ensure that you turn on the notification so that every time we release videos, you're able to know about them. And then also students that are interested in private law tutorial sessions, please contact us. Our number is down in the description box. You can call us and then we can make an arrangement to put you on a private session where you're able to be tutored by an expert lawyer. So let's start right away with what we're going to be looking at today. We are going to start by basically defining what judicial review is, and for purposes of the definition, I will refer you to go and look at the case of Pius Nwagaba versus Law Development Center. That case basically, court attempted to define what in law amounts to judicial review. And court stated basically that judicial review is a process by which court exercises supervision over decisions of public bodies. So basically what you have to note here is that judicial review in essence looks at the powers of court to exercise supervision over decisions of other bodies. So if a body makes a decision, then the court can always supervise, okay, such a decision to test whether indeed the decision amounted to the principles of rule of law and justice. So having laid down what judicial review is, let's now quickly run to look at bodies that are actually under the law considered to be subject to judicial review. So what are what are those bodies that are subject to judicial review? Is anybody subject to judicial review? The answer is no. There are some bodies that are not subject to judicial review. So we are now going to first look at bodies that are subject to judicial review under the law. Okay, what are those principles governing those bodies and which type of bodies are subject to judicial review? Now, from the onset, it is important for you to note that when we are considering, okay, whether a body is amenable to judicial review, whether a body is subject to judicial review, we will mainly look at two aspects. Okay, one, we will look at the source of power. Okay, we will always look at the source of power. If we are deciding whether a body is subject to judicial review or not, we'll always look at the source of power. For example, is the power of that body from statute? Does the body get its power from statute or for an act of parliament? If the answer is yes, then most probably such a body is subject to judicial review. Okay, so the source of power is the source from statute, you know. So that is always very important to interrogate the source of the power. So what you should note is that those bodies where the source of power is statute, then such bodies are subject to judicial review. Then also the second aspect we'll always look at is the nature of the function. Okay, if the nature of the functions of that body, okay, is of such a nature that it is analogous or similar to those of a government body, then the same body will also be subject to judicial review. So please note that from the onset. Okay, from the very beginning, note that we'll always look at whether the body gets its powers from statute, and then also the nature of its functions. If the powers are from statute, then such a body is subject to judicial review. Then if the nature of such a body is such that it is analogous or similar to such functions of a public body, then the same body will also be amenable to judicial review. And of course, if the answer is no, then the reverse is definitely true. Most probably such a body is not subject to judicial review. Now, having laid down those fundamental principles, let's now proceed to look at the bodies that are really subject to judicial review. Now, one is governmental or public bodies. Okay, and under these government or public bodies, here there are a number of bodies. Okay, but we are going to look at some governmental bodies that are subject to judicial review. For example, one, government ministries or ministers or departments of various ministries, all those are subject to judicial review. And authority for that position can be found in the case of R versus Secretary of State for Home Department, ex parte Venables and Thompson. This is the case of 1997, Volume 3, All England Law Reports, page 97. So basically, in this case, the House of Lords held that the Home Secretary had acted illegally by misdirecting himself in law by considering an irrelevant consideration. So again, we are seeing here the House of Lords subjecting a government department to judicial review. The other second government department or ministry that can be subject to judicial review is local authorities. So even local authorities can be subjected to judicial review. Authority, look at the case of R versus Ealing London Borough Council, ex parte Times Newspaper Limited and others. It's a case of 1986, 85 LGR, page 316. Basically, in this case, the court held that banning of the Times newspaper from the libraries of 3 councils was unlawful. So again, we are seeing here court subjecting a decision to judicial review, a decision of a local council. Then the other governmental body that is also subject to judicial review are what we call parole boards. You know, in prisons, there are always those boards that consider the punishments, consider the timelines within which maybe prisoners should live. So those are called parole boards. So even those parole boards are, of course, they fall, these are government organs, okay? These are government boards, okay? So they are also subject to judicial review. And authority for that position can be found in the case of R versus Parole Board. It's a recent case of 2005, UK, Volume 1. So basically, in that case, prisoners successfully challenged the procedural fairness of the Parole Board in respect of revoking their licenses. Of course, they had been released on license. The House of Lords held that the Parole Board breached their common law duty of procedural fairness by failing to offer the prisoners an oral hearing where facts were in issue which could affect the outcome. So again, we are seeing the court subjecting even a decision of a parole board to judicial review. Even here in Uganda, we have such boards, and you can go and interest yourself in sections 87 and sections 89 of the Prisons Act. Okay, you go and interest yourself. You'll see that there are those committees that are responsible for handling issues pertaining to prisoners. Okay, so those in Uganda are the equivalent of parole boards. Okay, so far we have looked at government ministries. We have also looked at local authorities. We have looked at parole boards. We are now proceeding to look at now a second category that is subject to judicial review, apart from what we looked at, which are governmental or public bodies. So the second class are judicial bodies. Okay, so judicial bodies are also subject to judicial review. Okay, but it's important to note that the following inferior courts and tribunals are also subject to judicial review by higher administrative courts. So the first one are magistrate courts. Okay, so there is authority for the position that even magistrate courts' decisions can be subject to judicial review. I encourage you to look at the case of R versus Hereford Magistrates Court, ex parte Rowlands. This is a case of 1998, Volume 1, Queen's Bench, page 110. So basically, when you look at this case, the brief facts are that the applicant received late disclosure of 2 witness statements which were helpful to the defense. Now, when contacted, the witnesses indicated they would give evidence, but on that specific day, the justices refused an application for adjournment, and the applicant sought judicial review. The court concluded that the applicants were deprived of a reasonable opportunity to bring forward relevant witnesses though through no fault of their own, and quashed the convictions. So again, we are seeing here court exercising judicial review over decisions of a chief magistrate court. However, be that the case, it's important to note that high administrative courts and above are not subject to judicial review. For example, decisions of the Court of Appeal, of the Supreme Court, or the High Court and above, such decisions are not subject to judicial review. And there is authority for that position in the case of Racal Communications Limited. It's a case of 1981 SC, page 374. And in that case, basically, the House of Lords held that when a power to decide a particular question was conferred by statute on a court of law, as distinct from a tribunal of limited jurisdiction, there was no presumption that Parliament did not intend to confer on it a power to determine questions of law going to its jurisdiction, as well as questions of fact, and judicial review was not available to correct any error of law made by it. So here the House of Lords basically was saying that decisions of those upper courts, okay, Court of Appeal, Supreme Court, and so on, are not subject to judicial review. As an exception, but the decisions of a chief magistrate court, those can be subjected to judicial review. Let's now proceed to look at another category of judicial bodies that are subject to judicial review, and those are tribunals. So even tribunals or decisions by tribunals can be subjected to judicial review. Authority for that position can be found in the case of R versus Immigration Appeal Tribunal, ex parte Khan Mahmood. This is a case of 1983, Queen's Bench, page 790. Basically, in this case, the applicant, who was a Pakistan, married a citizen of the UK with a no of convictions for prostitution, with a number of convictions for prostitution. Now, the applicant applied for citizenship, which was rejected, and was served to be deported on ground that his presence was not conducive to public good, due to inquiries made pursuant to his application. He appealed the decision to an immigration appeal. The tribunal unsuccessfully, of course, did the same, and then applied for judicial review. Okay, so he proceeded then to apply for judicial review to quash the decision, which was dismissed. On appeal, the decision was set aside by the Court of Appeal. So again, basically, we are seeing in this case the decision of a tribunal being set aside under judicial review. So this basically, the case comes to illustrate that even decisions of tribunals can be subject to judicial review. Let's now proceed to look at the third category, and that is non-governmental bodies. Okay, so even non-governmental bodies are actually also subject to judicial review. So it is not true that it's only government bodies that are subject to judicial review. Even non-government bodies can still be subject to judicial review. And here, for non-government bodies, basically would be looking at the nature of the function. Now, these bodies which are not part of government administration per se, but which exercise de facto public law powers. So they are not government bodies, but they're exercising like government-like kind of powers. Okay, their powers are similar, or the things they are doing, or their functions are similar to those of government. Now, although these bodies have not been established by the government or by Parliament, they do exercise powers that are analogous or similar to those of government. Okay, so as such, these will be subject to judicial review, provided such a body is exercising functions that are similar to those of government, then it is amenable or it can be subjected to judicial review. Authority for that position can be found in the case of R versus Panel on Takeovers and Mergers, ex parte data fin. This is a case of 1987, Volume 1, Queen's Bench, page 815. Basically, in this case, Datafin PC sought judicial review of actions of the panel on takeovers and mergers, which was neither established by an act of parliament or the royal prerogatives. In fact, it was set up in London to regulate the city code on takeovers and mergers of companies. The Court of Appeal held that judicial review was applicable in the premises and that its jurisdiction could be extended to a body which operated as part of a system which performed public law duties in the circumstances. So again, here we are seeing court applying a judicial review to a non-governmental bodies. Why? Because of the nature of the functions. The functions it was doing were very similar to those of government. But please, however, contrast that case of R versus Panel on takeovers and mergers, contrast it with another interesting case of R versus Disciplinary Committee of the Jokare Club ex parte Aga Khan. It's a case of 1993, Volume 2, All England Law Reports, page 853. Okay. Now, in this case, the Disciplinary Committee of the Jokare Club disqualified the Aga Khan's horse, which had won a major race. The latter sought judicial review of the committee's decision. The Court of Appeal held that although the Jokare Club regulated horse racing in Britain, which affected the public, but it wasn't subject to judicial review, and that the club was not a public body, and the powers it exercised were not governmental in nature. Its powers derived from an agreement. Please note that its powers derived from an agreement between parties, i.e. with Aga Khan, which gave rise to private, please note, which gave rise to private rights, which are enforceable by private law remedies. Please note, so for judicial review, where you have private law rights, those ones will be enforceable by private law procedures. Okay, you don't come under judicial review if you have private law rights which can be enforced through a formal suit. Then you proceed by way of a formal suit. So here, when we look at the case of Ara versus Disciplinary Committee of the Jokare Club ex parte Aga Khan, and we contrast it with the case of Ara versus Panon takeovers and mergers, we realize why in the case of Disciplinary Committee of Jokare Club, court refused to apply judicial review. Okay, why? Because of the principle that we talked about earlier from the onset, which is the principle of nature of the function. We will look at the nature of the function. Here, we are seeing in the case of Aga Khan that the powers of this committee of sorts were derived from agreement. Okay, parties had simply agreed. So court refused in the premises to apply judicial review. Then also important to note, please note, this is very important, especially on the aspect of the timelines within which a judicial review is applicable. Now, an application for judicial review must be made within 3 months from the date when the grounds of the application first arose. Okay, so you have 3 months within which to bring your suit under judicial review. The moment the 3 months have elapsed, then your time barred. This is always very important to note. So you must always look at the timelines as well. They would also guide you as to whether the proper remedy is actually judicial review. Authority for that position, you can look at the case of Kahora Enterprises Limited versus Uganda Revenue Authority. It's miscellaneous cause number 8 of 2012. And in this case, basically, court held that the remedy of judicial review was not available to the applicant because he was time barred as the application wasn't made within 3 months from the date when the grounds first arose. So the timelines are very important. You always have to ensure that you're not caught up by those timelines, which are 3 months. Now, having comprehensively looked at the bodies that are subject to judicial review, let's now proceed to look at those bodies that are not subject to judicial review. We are going to look at bodies that are not subject to judicial review. The first body are what we call religious authorities. So religious authorities are generally not subject to judicial review. Okay, please note that. Authority for that position, look at the case of R versus Chief Rabbi of the United Hebrew Congregation of Great Britain and the Commonwealth ex parte Watchman. Okay, this is a case of 1993, Volume 2, All England Law Reports, page 249. You can also find it in Weekly Law Reports, page 1036. Now, on the ground of suspected adultery, the chief rabbi of the Jewish religion exiled Watchman from the religion. The issue in this case was, could the decision to exile Watchman be subjected to judicial review? Court rejected. The court indicated that the functions of the chief were spiritual and religious and were such that government would not seek to discharge them in his absence. So we are seeing court refusing to apply judicial review in matters of pertaining to religious authorities or leaders. Let's now proceed to look at point number 2. Okay, that was point number 1. So point number 2, basically, a decision of a public authority to award a contract to one person rather than another. Such a decision is also not subject to judicial review. So the moment a committee or a person decides to award a contract to one party as opposed to another, you cannot apply for judicial review over such a decision, except where the contract is inconsistent with the applicable regulations, or he can show some broader breach of public law other than simple unfairness to himself. Okay, then court can make a declaration. But save for that, you cannot apply for judicial review, where a decision to award a contract to one party as opposed to another is made. Okay, authority for that position, I encourage you to go and look at the case of R brackets the Law Society versus Legal Service Commissioner. It's a case of 2007 EWCA Civil, page 1264. You can also find that same case reported in 2008 volume 2 World Law Reports, page 803. Then also another case, again on that principle, is the case of Mass Energy Limited versus Birmingham City Council. It's a case of 1994. ENV LR, page 298. All those cases help to support the point which I just shared with you. Let's now proceed to also look at another third point. Okay, these are situations that are not subject to judicial review. Point number 3, contracts of employment are equally beyond the scope of quashing and prohibiting orders. So these contracts of employment are also not subject to judicial review. Authority for that position can be found in the case of R versus East Berkshire Health Authority ex parte Walsh. It's a case of 1985, Queen's Bench, page 152. Basically here, the brief facts of this case were that the applicant, a senior nursing officer employed by the health authority, and a contract which incorporated the council agreement on conditions of service in the health service, was dismissed by a district nursing officer for misconduct who had no powers to dismiss him. He applied for certiorari by judicial review, and court held that where the terms of employment by a public body were controlled by statute, its employees might have rights both in public and private law to enforce those terms, but a distinction had to be made between an infringement of statutory provisions giving rise to public law rights and those that rose solely or independently from a breach of contract of employment. Court went on to state that in this case, the applicant was seeking to enforce not public but private rights under his contract of employment, and therefore his application was a misuse of the procedure of judicial review. I keep on emphasizing, and I'm emphasizing this for the third time, that you cannot seek to enforce private rights, okay, under judicial review. Private rights are enforced by other mechanisms through lodging a formal suit by either by way of a plaint or otherwise through the other forms within which a suit can be instituted. So judicial review is not meant to enforce private law rights. For private law rights, there are other remedies within which they are enforceable. But you cannot proceed by way of judicial review to enforce private law rights. Court will not allow you. That would amount to misuse of judicial review. And quite so, that's why you're seeing that even the House of Lords continues to emphasize this. Let's proceed finally to look at our last fourth point, which is purely private bodies. So purely private bodies or individuals are also not subject to judicial review. Now, even if a powerful private non-governmental body is not held to be subject to judicial review, there appears, however, to be some evidence that the court or the courts, in the context of private law proceedings, may nevertheless subject these bodies to certain administrative principles. Okay, for example, acting fairly and not capriciously, or what we call changing mood or behavior suddenly and unexpectedly. This appears to be the context of some cases. Okay, so here basically the point we are laboring to explain is that for purely private bodies and individuals, these are not subject to judicial review. But even if they are not subject to judicial review, please note, emphasis is, court will still not go on to see unfairness being conducted, unfairness being applied on certain persons just because they are purely private bodies or individuals doing this. Court will ensure that at least it upholds, okay, the rule of law. Okay, court will ensure that it upholds those principles of justness and fairness, among others. Authority for that position can be found in the case of Nagle versus Feilden. It's a case of 1966, volume 2, Queen's Bench, page 633. In this case, the stewards of the Jockey Club controlled horse racing on the flat throughout Britain. No one was allowed to train horses unless he held a license from them. The plaintiff, a woman, had trained horses for many years, and it was the club's practice to refuse grant of license to a woman in any circumstances, although the licenses were actually granted to her male servants. The plaintiff brought an action against the defendants, seeking an injunction and a declaration that the practice was void as being against public policy. Court held per curiam on appeal that acts that are arbitrary, unfair, unjust, unreasonable, and capricious attract court's intervention. So this is the point we are laboring to explain. That whereas this was an action of a purely private body or an individual, whereas it was not subject to judicial review, but because it infringed on the basic principles of fairness, human rights, okay, and justness, as such court had to intervene. So the moment such actions of an individual, a purely private body, whereas not subject to judicial review, but if they go on, okay, to violate those natural rights of fairness, justice, equality, among others, then court will definitely intervene in the premises to ensure that justice is served. So ladies and gentlemen, that is all we had today. And just a quick reminder of what we have looked at. We have looked at the definition of judicial review. We have also looked at bodies that are subject to judicial review. We have also looked at the timelines within which judicial review has to be applied. And then we have also looked at bodies that are not subject to judicial review. Once again, I encourage you to subscribe to my channel. Just below there in the right hand corner, there is a red button. Just click on it. Also ensure that you turn on the notification so that every time videos are released, you are in the know. Also, students that are interested in having private law sessions with me, please ensure that you contact me directly, and then we will put you on our expert program. Our contacts are down in the description box. See you in another video which will be released. Thank you very much. Bye-bye.